let's see if there are any questions from the committee in terms of this question. Any questions, members? I'm struggling with, I guess, what you said, Mr. Brown, at the end, that if the legislature chooses to get into this and come up with a definition, is it going to help the situation? I mean, if we just legislated the Holly factors, for example, what would that do?
You want to answer?
I'll go first.
Okay.
I don't support legislating the Holly factors because that is a unique case that involved TPR, and it would go against what the Supreme Court even said about its own opinion, that these may be considered, they're not exhaustive, and they may not apply in every case. Based on our research and what we've seen in other states, that foundational definition, right? This is the most basic fundamental principle for the court to apply when they start, at least gets you closer to a more uniform application. You're always going to have unique facts of cases. You can't control for that, and I think for the legislature to try to do that would create more confusion. But making sure that all of our courts have a consistent understanding of what best interest means will take away a little bit of that. If I know it, then I see it, and specifically some of the subjectivity that comes in where it matters what court you end up in as to what the judge is going to say is in the best interest of your child, right? And that's where, especially in family law, we have a lot of challenge because in a lot of cases, it does matter which court you get into on how they're going to be applying the various standards. And I think that creates a lot of frustration for families, creates a lot of frustration for attorneys across the state who are trying to figure out, well, what does this mean in my case? Because courts are so divided and all over the place over this very issue.
And then you've got, every case is different.
Right.
Every case is different, every situation is different, and we as legislators are trying to prescribe the playing field for all of them.
Well, and best interest is listed in a lot of different places. You have best interest of the child for conservatorship. You have best interest of the child if you're not going to follow the standard possession order. You have best interest of the child in child support, in adoptions, in determinations in CPS cases. And I don't think that those definitions will look the same. And so I think if you want to tackle defining best interest, then you're going to have to tell the judge, okay, well, if this is a termination case, then this is what best interest is going to look like. But if this is a child support case, then this is what best interest is going to look like. And I don't really debate that it would be wonderful if we had more consistency among the courts, and certainly that was challenging in Harris County, where we had so many family court judges and associate judges who had different at times kingdoms, for lack of a better word. I'm not sure that you can legislate better decision making by the judges. I think the judges who really want to do the right thing and do it well are going to read the case law and be familiar with the code, and they're going to do what really is best for that child, rather than saying, okay, well, let me open the code like they do with child support guidelines and say, well, this is what you get because everybody else in your situation gets the same thing, because the kids are just so different. And I do agree with him. Consistency would be better, but I'm not sure trying to define best interest of the child in 5 different places or 12 different places is really going to bring about the consistency that you hope it will accomplish.
Mm-hmm. Okay, show Mr. Cook, the guy who started all this, present. So best interest of the child itself is a standard that can change depending on the situation.
It can.
Then should we try to create a standard for each one of those situations?
Well, I think part of the problem with trying to define best interest, and he's touched on this, and I totally agree with him, every case is so different. Mm-hmm. And it might be in the best interest. I had a judge in Jefferson County one time find it was in the best interest of children to go to tennis lessons. because it was what they had been doing. They were embroiled in this horrific fight. It was one thing the judge could do that would be some consistency. And that's not, and I'm not suggesting that you would try to legislate every single circumstance, but that's an example of a time when a general definition of best interest isn't going to help the judge. You're going to need a judge who really cares, has listened to the evidence and thought, you know what, this kid really should keep going to Kincaid, or this kid shouldn't keep going to private school, or have tennis lessons, or carry a cell phone, or because there are so many issues that come before us. And as a practical matter, we've been doing this. I mean, I remember one of the first cases when I went on the bench in 2005 was over shin guards in soccer. And so the fundamental issue was, well, is it in the best interest of this kid to keep playing soccer? I mean, what are we doing with some of these issues? And I don't mean to minimize the significance by putting up a trivial example, but it really is true that every one of these kids has very unique needs, and that what may be in this child's best interest may actually not be in the next child's best interest.